along those lines, okay?
Yeah, and can I say something? They told me that I had to run this thing down. I called MoneyGram. MoneyGram said that one money order was cashed on the 7th. Another one was cashed on the 8th. What the heck? What the heck?
Our calls the case of people versus Zachary Radcliffe.
Good afternoon, Your Honor. Amy Reiser, appearing on behalf of the people.
Your Honor, James Thomas, or Ms. Radcliffe.
Okay, what are we doing?
Your Honor, today is the time and date set for the probable cause conference, and all of the discovery has been provided. There are still some electronic devices that are outstanding, but I don't know when those will be done. So I think we could get an exam date, and I would be requesting a special date. I think it will take like a full day.
All right.
Well, Judge, just let the court know, she did provide 8 videos on Monday that are, I don't even know how many hours of videos that I have not had an opportunity to even look at yet. These were things that were requested over a month ago and just got them Monday this week, which puts me in a predicament because obviously my guy's locked up and I would want to have my client be able to watch these videos, which calls into question his bond and the amount of his bond, because I would like to seek or at least ask for an oral motion to set a bond or reduce his bond at this time if the court would entertain that.
Well, I'll always hear bond, but I guess I don't understand your rationale for bond is because you can't view the.
Well, there's a couple of reasons for it. One, obviously the limited contact that I'm able to have with my client as far as all the hours of evidence that they just provided to me this week, for one. 2, when he initially was in his preliminary presentation, there was not an assessment that was done whatsoever for the bond. He had an attorney there, but according to my client, the attorney really didn't say anything on his behalf, and a $3 million bond was put into place. And at that point, none
All
of
right, counsel, if you want to argue that he didn't have an adequate opportunity to argue bond, I think each time you've been here, that issue has been brought up.
never.
But if you, okay, then fine. You want to file a written motion? File a written motion. We'll give you a special time. I'll give you all the time in the world. I'll hear your bond motion. How long will it take you to do the motion?
I could have it this week, Your Honor.
People need about 7 days to respond, if that.
Yes, Your Honor.
But the only thing I'm out of the country from the 21st to the 28th of January.
I got a holiday before that, so I can't, if you're not here till the 28th, I can't hear till the end of the month.
What day do you hear them on, Your Honor?
I hear them on Thursdays in the afternoon.
What day does that fall on?
Pardon?
What day does it fall on, Your Honor?
What do you mean?
The one that you were thinking about putting it on.
Well, if you're out between the 21st and 28th, the only Thursday I then have is the 30th.
I mean, I can make the 30th work if that's the earliest we can get.
Set probable cause. I'll adjourn the probable cause conference and set the bond motion to January 30th, 2025, 3 p.m. That is before me at that point for the bond motion.
Judge, would you like a courtesy copy to your email or to?
I think the court rules require that you need to send me a copy so you can deliver it to the court, or you can send it to the email of my clerk or
Yes,
my staff.
I suggest we set an exam date.
It's not going to happen until discovery is all complete. He's saying discovery's not, I'm not going to do it. What I'm going to do is he wants to hear the bond motion. I'll hear the bond motion. It says that you just got discovery to him. I don't set him that way. I'm not going to set it. I'm going to hear the bond mark. 30th.
And so I just want to make sure we're all on the same page. The discovery that he doesn't have may never come because it's passcode protected.
And then I understand that because that was brought up before me before. If he wants to give him the passcodes, then I think that discovery can get there, but I don't think that's going to happen. So I'll hear the bond motion on the 30th and then we'll see where we go from there.
Your Honor, just so I know, I know that she's saying that there's other stuff that's out there possibly with subpoenas and stuff that she has out there. I'm not sure where
What
they're,
subpoenas?
No, I didn't say that.
well, is there other notices out there for anything else that you're doing with, other than his?
I hear that there is electronic devices that are password protected that is going to take some time to get into, that he may have the passwords to, but I don't think he's going to give them. So we're just going to have to wait on that. I mean, that's what I'm hearing. Anything else?
No, thank you.
No, sir.
Wonderful. We'll see you on the 30th. Hey, guys, hold it, folks. Hold on a moment. Who's who with, is that everybody? I just want to make sure. So anybody with defense counsel that was here, they've left already? Or they're on their way out? Okay, let them go first. I know I try to alternate, but I probably got it all wrong, folks. I'm sorry, but I just don't want anything. Let them go. And then, folks, if you would be patient, once they've cleared, then those folks can. Thank you. Court calls the case, People versus Desiree Radnovich.
Yep, right here.
Okay, hello.
Interrupt you on behalf of Ms. Bogdanovich. Judge, we've adjourned this PCC. Due to the holidays, it was tough to get an appointment with her. I have an in-person appointment with her tomorrow at the Huron Valley Women's Prison at 10 a.m. Could we just adjourn this PC maybe 1 week?
Are we kidding again?
I have to go 2 weeks because I can't.
That's fine. Ms.
Because she's
Bogdanovich, no matter how hard I tried, I just couldn't get a visit with you because of the holidays. That's what they
I
told
mean,
me.
I've been sitting in front of the phone for 4 hours waiting for you to call on 2 occasions. I don't feel like you're trying to contact me at all.
I can't directly contact you. I have to go through the system and they wouldn't allow it.
They had me sitting in front of a phone for you.
Hey, hold on, folks.
I'll be there
Okay,
tomorrow, 10
Hold
a.m.
on. Maybe he's supposed to be down there tomorrow. I can't rectify what may have occurred in the past, and we'll get you heard as soon as we can, okay?
Okay.
Sir, your name?
Emerson Wilson.
All right, what, you're requesting an adjournment?
I'm asking for an adjournment, Your Honor.
And we have a new bond violation report.
Yes, Your Honor, I'm in receipt of that. I don't know if a warrant didn't go out.
Pardon?
A warrant has not gone out on the case.
You want me to issue one?
No, Your Honor.
All right, let's address it then.
Addressing it, he does have an appointment today for a medical marijuana card. The last time I talked to him, it was you can't use until you obtain a potential card and seek that permission from the court. That didn't get done quickly. However, he does have an appointment today. He did provide me proof. We're working on negotiating a potential resolution in this case. He understands and can direct to the court that he will not use until.
Has he been using? I mean, and so before you answer, understand, I don't want to call over and get levels, but I will.
Speaking with him, and he's willing to tell the court today as well, is.
Now this is where things escalate. The defendant openly admits to violating a court order, using marijuana before getting proper approval. And here's the key issue. Intent doesn't matter as much as compliance. Even if he thought he was doing the right thing, the court only sees one thing: he broke the rules. And just like that, Judge Simpson revokes his bond. No long lecture. No second chances in that moment. This is a reminder: when you're on bond, you're already under scrutiny. One mistake and everything changes. Be honest. Should the judge have been more lenient here?
Yes, Your Honor. He's been defying the court order. He thought that him obtaining a card was enough for starting that process. But he understands now and will not be using. And I think if we go out to the 30th, the levels will be going down until he gets permission from the court.
Probable cause conference will be adjourned to January 16th, 2025, 9 a.m. This time defendant's bond is revoked, defendant's remanded.
Judge, my client did want me to address one issue regarding bond, if you don't mind.
Go ahead.
Thank you, Judge. I explained to my client the statutory requirements for a child support case and his bond. He wanted to make sure that his bond, to ask the court to set this bond to the lowest possible amount. I told him I thought it might be there already, but he wanted me to confirm that with the court. And if not, he wanted to have it reduced to the lowest possible amount.
His bond is set at $3,476, which would mean that he would have approximately owed somewhere in the neighborhood of, I don't know what his current obligation is.
I can let you, Your Honor. I can explain that. His current obligation right now is $15,370.58. That's as of January 6th. He has an ongoing support obligation also of $203. The defendant hasn't made a payment since August of 2023. Technically, the bond should be a little bit higher. It should be about $3,800 right now. But
Right.
but I'm not going to make an issue out of that. So
It is the lowest possible. Thank you, Judge.
Well, it's lower than the
It's
lowest
lower.
possible.
So it's
Do
not.
you want me to change it?
Not at all, Judge.
Okay, then we're
Okay.
done with that conversation?
We are, Judge.
We are.
Thank you.
All right, bond will continue. Thank you.
thank you, Your Honor.
The other thing is that I won't address it today, but he may need to appear in person because I've got a violation report from Community Corrections regarding missed samples, 3 consecutive ones.
I actually had a hard time getting to these appointments.
Sir, you might want to talk to your attorney before you start addressing me on that.
Okay.
Positive for THC.
Yes, there was a positive for THC back on December 18th and then 3 successive misses. And prior to that, there was an unable or refuse. So here's what I will do. Sir, you're going to need to arrange to be at the courthouse. We will try to get what information we can to you, counsel, so that you can contact him. But I'll adjourn this out just 1 week to the 16th.
I have a court date on that day.
Pardon?
I have a court date on the 16th at 9:30.
Where?
I'm pretty sure it's going to be at 14-2.
14-2?
Yeah.
Okay,
Yes,
we're
Your
right down the,
I also
we're right
have
down the
a-
street.
Your Honor, I also have 2 other matters that morning. Would it be possible to adjourn 2 weeks?
Well, I think that I need to address his bond violations. Otherwise, I'll just revoke his bond. We'll come get him and then we'll set it whenever we're ready can be here. Which way do we want to do this?
Well, I understand, Your Honor. We will make arrangements to be there. I'll talk to your court clerk about. coordinating.
Fantastic.
Judge. And I
Probable
do
cause.
have Mr. Tournier's phone number from the chat. So Mr. Tournier, I'll be calling you when we hang up here.
Okay.
January 16th, 2025, 9 a.m. Bond
Thank
at
you,
this
Your
time. Bond at this time is continued. Thank you. Court calls case of the people versus Kyle Rainey.
Public Convention, I'll be acting really, Your Honor, on behalf of Mr. Cal Rainey, who is approaching.
That's what I was looking for. Why? Go ahead.
Your Honor, today is the date and time set for probable cause conference in this matter. I know the court would want to first address Mr. Rainey's bond violation.
Yes.
I know. So, Your Honor, Mr. Rainey was released from custody. I don't have the date in front of me. However, upon his release, Your Honor, he
left the state.
He did. He left the state of Michigan and he went to Indiana. When he was released, Your Honor, he indicated to me that he was displaced and he did not have a place to stay. He did have a tether on. He indicates that he contacted the tether agency. He contacted the emergency number to see if he would have permission to go and stay with his grandmother in Indiana. He states that he did not receive any information back. I did not receive any contact from Mr. Rainey, but it was during the holiday period, Judge. He has been in contact with us.
Was there a call to your office at all?
There was a call to my office. He called us. It wasn't prior to him going. I will say that. However, he did call and say, I'm in Indiana. I didn't have anywhere to go. I've been trying to reach out to my agent, but to no avail. He's got that other case in Hillsdale County. He's been reporting. He's currently on probation there. He has been testing. To our community.
No, not serious.
Okay. He is Your Honor, he has not been using any substances. He has been clean. The only reason he went there was because he did not have a place to stay. He stays with his grandmother in Indiana. I have explained to him that prior to leaving the state, he has to receive permission from the court to enable him to go wherever it is that he's going to
I
go.
ended up getting in Litchfield one day.
Okay, he indicated that he was
You
only
need to take
in,
your hands out of your pockets.
he indicates that he was only in Indiana for 1 day. He has been back now.
1 day too long.
1 day too long, Your Honor. He has been able to secure housing here in Michigan, in Litchfield.
Litchfield, Michigan, where I'm from.
In Litchfield, Michigan, where he's from. Your Honor, he has been very, very active in this case right from the beginning. We know that it took us a minute to get him out of custody. And obviously, he does not take that for granted, Your Honor. His violation of this bond was not, although it was very much so a violation, Your Honor, he doesn't want the court to perceive it to have been a disrespect to the court. He takes this case extremely seriously. We've been working with the people to see if there's a resolution. Right now, we do not have a resolution, mainly because this outstanding issue needs to be resolved first. We're asking that the court allow him to stay out. The tether is doing exactly what it's supposed to do. Obviously, it didn't stop him from going, but he knows now that he is.
This might be the most emotional moment in the entire hearing. The defendant admits the violation, but tries to justify it with personal hardship. No housing, winter conditions, no support system, and while that might sound reasonable on a human level, legally it doesn't hold. Judge Simpson shuts it down immediately. You knew. That line says everything, because in court, awareness equals responsibility. And this is where the system draws a hard boundary. Your situation can explain your actions, but it doesn't excuse breaking court orders. So what do you think? Should life circumstances matter more in decisions like this?
No, he knew then.
Your Honor, I did know then. I had nowhere to go. I was left out here. When I got arrested, I was in summer clothes. They were able to give me a hoodie. It was the middle of winter. I contacted everybody that I could contact. And I apologize.
No, you didn't contact everybody you could have contacted. Did you get a response? Any response from the people?
The concerns of the people are just, I think the court recalls when we were here last time, the defendant was able to secure a PR bond after having been spent 7 months in Hillsdale, coming back here. So when he was gone, he wasn't gone somewhere else. He was in Hillsdale. But the concern is still that there was a failure to appear, I believe, at some point during the case. That may not be accurate, and I apologize if it's not. But the issue is he was on bond for a CCW at the time of this possession case. He leaves the state, and I don't know if he's been testing. I don't have that information. I don't have anything to say he's not. I just don't have any information he has been testing. And there are clearly had the ability to get all the way to Indiana. So I'm not sure why there wasn't some sort of communication with his attorney or something else to make sure that he was gonna follow the bond conditions that were set by the court.
And Your Honor, if I may, just very briefly, he indicates to me that he has been testing. He's been testing in Hillsdale. He's on probation out there. His attorney in Hillsdale, he states that she forwarded the testing results to Community Corrections. I don't have a copy of that. I can absolutely reach out to them and see if I can get that. But Judge, we're really asking that the court give him another opportunity. He's been in custody for 7 months, in and out of Hillsdale. I mean, between here and Hillsdale.
And he just needs to follow the court's orders. It's really simple. Anything else?
Like I said, I got a place here.
Nothing else, Your Honor. He just wants the court to know that he does have housing in Michigan now.
Probable cause conference will be adjourned to January 16, 2025, 9 a.m. This time the defendants remanded on the warrant. Community Corrections for violation of his bond.
Thank you, Your Honor.
Casey Matson, P87729 on behalf of the plaintiff.
Hello, sir.
Hello.
How are you?
I'm doing just lovely. Thank you for asking. How are you? All right. And also Dorothy Williams. All right. So last time we were here, there was 1,066.69. How much is owing at this point?
Your Honor, I have rents to retain of $856.64. Cost of $240 for a total of $1,096.64.
Yeah, went up a little bit. All right, how are we gonna get this paid off?
It's already paid, sir. They lost it.
Okay.
They lost my rent.
Hold on.
I have receipts. I gave them receipts. She took a photocopy of it.
Who?
The lady that was up there in the rent office. Her name was Dana. We don't have management because everyone has quit. And my rent came up missing, and the woman that was there, she quit or got fired. Now,
All right. Are you gonna have your January rent?
yes,
Okay, when are you gonna pay your January rent?
on the 3rd,
Okay, then here's what I'm gonna do. What's your monthly rent?
$657 plus the water bill. My mother is 94 years old.
Yes, I recall, ma'am, the last time you were here.
I'm trying to stay calm, sir, but I am so upset because I have never went without paying the rent. And here these people got me up in here defending myself, and I got receipts, a bag of receipts, a bag.
So you pay your 657 plus whatever your other charges are. You're to pay that by January 3rd, 2020.
Yes.
25. Okay.
Yes, I pay it
Pay
every.
that rent. So this way the number doesn't get worse. So everything is done, and then we can try to figure out where we go from here on this. I'll adjourn this then to January 10th, 2025 at 3 p.m. Hello.
3 p.m.
Okay, at 3 p.m. Okay.
Yes,
And
sir.
we'll figure it out in terms of what was lost and when it was lost and anything along those lines. Okay.
Yeah, and can I say something? They told me that I had to run this thing down. I called MoneyGram. MoneyGram said that one money order was cashed on the 7th. Another one was cashed on the 8th. What the heck? What the heck?
Okay.
And then you're gonna send me papers talking about find it? You find it. I told them you lost it, you find it. Doggone they time. I'm not happy. I'm not happy. My mother is 94 years old. She has a colostomy bag on one side and a tube in her gallbladder on the other side. We cannot afford not to pay our rent. She's 94.
Ma'am.
Doggone they time.
Ma'am.
Yes. Yes, sir.
What I need you to do is, if you got confirmation that those were cash, I need you to get written confirmation from MoneyGram that that has happened. Bring that to the next hearing.
Okay.
Because that's going to be important for us trying to figure out what happened.
Okay.
Okay.
Okay, sir.
All right.
Happy New Year, Judge Simpson.
Yes. Thank you.
And Happy New Year to everybody.
Your Honor,
Yes, ma'am.
is that amount to be paid for both this matter and the past matter to my client, or are we putting that in escrow with the court?
She's going to pay it to your client. She's gone, but that's where I'm sure she's going to pay it because
Okay.
your
Thank-
client's going to have to hear it. Okay.
Carissa Gazari, appearing for plaintiff.
Good morning, I'm here. I don't know what's wrong with this phone.
Use iPhone 1. Okay.
Judge Simpson, can you hear me? Oh,
Yes,
Lord.
yes, ma'am. I can hear
Okay.
you.
Okay.
Okay, I can't see you, but we
I'm
can hear
trying
you.
to get it. Oh, God. Okay.
Okay, it's okay. There you go. We got you. Now I see you. Now I hear you. Okay.
Okay.
Okay. Nice hat. All
Thank
right.
you.
Okay. Mrs. Harry, how much does she? What's the plaintiff's claim?
The outstanding balance is $2,275.69, which includes $172 in court costs.
Okay, Ms. Mills, how are we gonna get that paid?
So Judge Simpson, I have all of the money in my account. I just have refused to pay it because I am going through some tremendous problems over here. And I wanted to wait until I talked to you. I've been trying to reach out to legal aid. I've reached out to Melissa. I'm having a mice issue here. I have pictures of all of this. I'm still having issues of like a black substance coming through my vents, getting in my freezer. It's a wreck over here. So I got upset and I just refused to pay because I've been without heat for 7 days. These past I'm having to relocate to family members' house, and they haven't even came. They've been like half fixing my stuff over here, and I'm upset about it. And I feel like I don't want to pay them until I figure out what's going on, because I feel like they're getting down on me. And I'm like, I'm just gonna hold my money until I talk to the judge, because I want out of this lease, because I'm not comfortable here, Judge Simpson. I am not comfortable here at all.
Okay, let's do this. All right. I need you to file a written answer with the court laying out all of that. Okay, I'll give you to January 6th to get that done. Okay?
I don't know how to do
all
that.
of you.
Can you tell me how to? I'm sorry.
It's okay. You can, if you put it on paper and just say, here are my complaints, that'll work for right now. Okay? Okay, and this is why I'm not paying issues. If you get through legal services, they can do something more formal, but let's try to just get chiefly what your complaints are right now, okay? Now, you say you have the 2,275.69?
I have it right now. I was
Okay, hold on.
trying to move.
Hold on.
Okay, I'm sorry.
Hang on. All right, here's what I want you to do.
And this right here is a textbook judicial move. Instead of picking a side too early, Judge Simpson introduces escrow. And this is crucial. By placing the money with the court, he protects both parties at the same time. The landlord knows the money exists, and the tenant knows it won't be unfairly taken without resolving the issues first. It's a neutral ground. And honestly, this is how courts maintain fairness when facts are still unclear. No emotional decisions, no rushed rulings, just controlled, structured process. But here's something to think about. Do you think this is the fairest solution, or should the judge have taken a stronger stance immediately?
I need you to put that in. Why don't you put that in the court escrow along with your January rent? Okay. Now I'm having you do that because I got to protect the plaintiff's interest. I got to protect your interest.
Okay.
Once we get through the issues regarding everything, I'll just figure out how I'll split it. Probably nobody will be happy or somebody will be unhappy, but we'll figure it out at that point. Okay.
So can you tell me how to do I come to the court to put the 2,300?
Yes. Yeah, you have to come to court, put that in the court escrow. It has to be in cash.
I'll come. Okay, I'm on the way. I'll come now because and Judge Simpson, I really want out of this lease. I don't feel like I should be penalized. I want some. I couldn't even have a good Christmas or anything because there's mice. There's things going on here. I don't even want anyone here because it's embarrassing. And I pay all this money. And
Okay, Miss Mills, I heard you when you said what you wanted. I did. Okay.
Yes,
so
sir.
I don't know how to get there. When does your lease expire? Do you know?
My lease expires in July. I'm trying to get out of here in the next few months.
Okay. Miss Mills, I hear you. It's okay. I'm hearing everything you're saying, and I know you're trying to just tell me all of that. Okay. So just do this. Get the escrow paid. I'll set a hearing then for January 10th, 2025 at 12 noon. That's in person.
Okay.
Okay.
Can I tell you one more thing?
Can I stop you?
No. Yeah, you can. You
No,
I just wanted to let you know that my January rent is going to be late. I can't pay that until a week from now. But I have the 2,300 right now.
Okay, put the 23 in, and then you think you'll have the January rent by what? Will you have it by the 9th?
Yeah, I get paid every other Wednesday, so not next week, but the following week.
Gotcha. On the 8th, you get paid.
Yes, sir.
And so you'll have it on the 9th. Okay. Just put that put the 23 or 25, 2275.69, put that into court escrow now. And then the January rent, get that in by the 9th.
Okay, yes, sir.
All right, of January. And then I'll set your hearing for the 10th at 12 noon.
Okay, thank you, Judge Simpson.
All right.
Have a better day and happy holiday.
Yes, and happy holidays to you. Get that written answer. Get that list into me, okay?
Yes, sir. Okay.
All right. You
Thank
take
you.
care.
You too. Bye-bye.
I'm gonna get a hat like that too.
Thank you,
Take
Judge
care.
Simpson. Bye.
All righty. Bye-bye.
Oh, okay. Can you hear
That
me?
matters. Yes. Your name is Miss There?
Yes, Elizabeth, yes.
Okay, your case is dismissed.
What about the 50, I have two $50 late fees that I've been charged for November and for December. And as I
Now this is where things get surprisingly technical. A 100 dispute might not sound huge, but legally it matters. Because once a case is dismissed, it's essentially closed. And that means those fees stay as they are. The tenant realizes this instantly and pushes back. And the judge makes it clear, you can't have both. You either accept dismissal or you continue the fight and let the court investigate. This is a critical legal lesson. Every decision in court has consequences. Even something as simple as dismissed can work against you. So let me ask you, would you fight for that 100 or just let it go?
I have received, everything's been paid, even January. So I should, and it was never late. Nothing was ever late. So I would ask the court to refund, that they refund that $100.
Ma'am, I
Yes.
can't do that. What I can do is I cannot accept the dismissal, set you over to the 10th, and we can get it worked out then.
You're saying if I accept your dismissal, I have to accept that they charge me an extra $100?
Ma'am, I am not saying anything. If you don't want me to dismiss it, I won't dismiss it. I will set it on its litigation track. You will get it set for January 10th.
Okay, but where does it stand right now about the late fees when you said it was dismissed? Okay.
Here's what I'm gonna do. Ms. Kazari,
No,
I'll
I
let
don't
you
wanna-
guys,
I wanna dismiss
I'll
it.
let,
No.
ma'am, here's what I'm gonna do. Ms. Kazari, I'll let you check into the late fees on this. I'm going to adjourn this over to January 10th.
Can we please
2000
dismiss it?
Pardon?
Can we please dismiss it? I just want it to go away. There's all kinds of problems here at Huron Vista. And I guess you're not the one to talk to about it, but I just
Well,
want this
ma'am,
problem
I
to go
will
away.
deal with it, but I can't deal with it today. I don't have a ledger in front of me. I can't even begin to work it out for you. But I will do,
Okay,
if you
but-
don't want to dismiss and want the $50 for each of those months, at least somebody to look at it, I'll set you over to another date and I'll look at it.
Okay, but do I have to come in person? I don't have a vehicle and I'm a senior and I'm disabled.
Here's what I'll do. January 10th, 2025 at 12 noon, I will permit this time you to appear in or by Zoom. All right? Thank you.
This entire courtroom session highlights one powerful reality. Justice isn't always immediate, but it is methodical. In every case, Judge Simpson focuses on one thing: evidence over emotion. Whether it's missing rent payments, unsafe living conditions, or disputed fees, the court doesn't rush to judgment. Instead, it builds the case step by step, through receipts, written complaints, escrow protections, and due process. And that's what makes these hearings so important. They're not just about who's right or wrong, they're about proving it. If you found this case as intense and eye-opening as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.